they get lobola paid into their accounts, like the mother of the applicant. Her cell phone rang, and when she looked at it, oh, there's a deposit of 101 notes. Now, that's a departure from the African traditional culture. Then 21.4, the two families would have to agree on the formalities and the date on which the applicant would be handed over to the family, and the handing over of the bride to the family, normally accompanied by a ceremony, would have to take place. Right, let's pause. In traditional African culture, the parties who intended to marry never cohabited together before the negotiations for the lobola. But because times have progressed, you have fat and set, as it is called. Like in this, they cohabited for about 9 years. In this case, in African traditional society, the parents of both parties actually should abjure this conduct that you can't live with somebody's child before that child has been announced as your bride in our house. But this didn't happen because the culture now has been superseded by modernity. And Mr. Tambo says the handing over of the bride to the deceased did not take place. The most crucial part of a customary marriage is the symbolic handing over of the bride to the potential husband's family. In the circumstances, no customary marriage was concluded. The applicant's counsel has given us about 19 cases where this is not a prerequisite. Am I correct, sir? The handing over. Yes. And Mr. Mahon, the respondent, has also given us about 5 cases where they say the handing over is a prerequisite. So even judges differ. Slope, who is a senior judge, Judge President Slope, he says it's not a prerequisite. Various other judges say that. And I'm going to quote some of the judges who are of that view. Sorry. I'm going first to quote the case of MMN and Ms. MFM, and Minister of Home Affairs. This is a case of the SCA. The judgment was delivered on the 1st of June 2010. Just illustrates the principle. Paragraph 22, the learned judge states that the section of the Act dealing with validity of a customary marriage, that is Section 3, is not by any means related or linked to Section 7.6. In striking a balance between the text and the context of the Act, the preamble states that the purpose the Act seeks to achieve and specifically refers to the validity of customary marriages. The requirement for validity of a customary marriage is in 3.1. And he repeats and he says, these are simply: 1, spouses must be above the age of 18. 2, they must both consent to be married to each other under customary law, and the marriage must be negotiated and entered into or celebrated in accordance with customary law. Paragraph 23 says the Act does not specify the requirements for a celebration of a customary marriage. In this way, the legislature purposefully defers to the living customary law. Put differently, The requirement is fulfilled when customary law celebrations are generally in accordance with the customs applicable in those particular circumstances. But once the three requirements have been fulfilled, a customary marriage, whether monogamous or polygamous, comes into existence, notwithstanding the sanctions of non-compliance of Section 7C, which is a different matter. But what is important, what this judge is saying, he says, once the three requirements have been fulfilled, the three requirements in this act, there's no handing over here. Don't confuse that. The three requirements: the spouses must be above the age of 18. 2, they must both consent to the marriage to each other under customary law. And 3, the marriage must be negotiated and entered into or celebrated in accordance with customary law. The Act does not specify the requirements of a celebration of a customary marriage. In this way, the legislature purposefully defers to the living customary law. The living customary law. This is the dynamism of the customary law, with it's not static, changes as people, I'm not going to say get civilized, adopt other cultures in pursuance of their own culture. We put on diamond rings today. There were no diamond rings, for instance, to signify that you are married. So this is what the living customary law is talking about. It says, put differently, this requirement is fulfilled when the customary law celebrations are generally in accordance with the customs applicable in those particular circumstances. But once the three requirements have been fulfilled, a customary marriage, whether monogamous or polygamous, comes into existence. It's not me saying that, it's the SCA. So the judgments which have been paraded here cannot supersede the judgment of the SCA. So, in short, the conflation of customary law, as enunciated by Mr. Robert Sambo, that there must be a handing over. The bride must come home. It's not a requirement in terms of this act. The handing over, it's not a requirement in terms of this judgment. If the three requirements are satisfied, there is a customary law marriage. Now, sorry, so many papers, I'm drowning in paper here. Did you leave that judgment here, Mutuna? Okay. Another judgment here, SABC. Yeah, just hang on, please. There's a judgment I want to quote from this court. Yeah, it's here. Sorry. Yeah, right. I'm just going to quote some of the legal principles encapsulated in the judgment of Southern Elizabeth versus Maropane Mohau Jackson. It's a judgment which was delivered in this court by Judge Salduka, who is now in the SCA, on the 18th of July 2012. And she also was prescient to recognize that there is even a conflict between experts. In this case, two so-called experts in traditional African law testified, and all two of them differed as to what customary law relates to. That's why I say there is no unanimity. Here there was no expert who testified. In this case, two professors testified, and they alleged to be professors in in customary law, but they also differed. But let's start with Slope. In Mabuza versus Mabuza, 2003 for SA 218 Cape at paragraph 25 and 6. This is what J.P. Lopez says. He held that the customary law was a flexible and evolving system of law. And in that case, a dispute arose about the existence of a customary marriage. The husband sought to deny it on the basis that certain customary rituals, ugumekeza, whereby a bride is formally integrated into a husband's family, is an indispensable component of Swazi customary law. According to the husband, this had not been observed. Although he had referred to the woman as his wife, lobola was negotiated and paid in full. The wife handed over to his family. Lopez stated the following in regard to the custom: that in my judgment, there is no doubt that ugumekeza, like so many other customs, have somehow evolved, so much so that it is probably practiced differently. Further support for this view that African customary law has evolved and that was always flexible in the application is to be found in Dr. Bennett's book, A Source Book of African Customary Law of Southern Africa. Professor Bennett quite forcibly argued that, in contrast, customary law was always flexible and pragmatic. Strict adherence to rituals formally was never absolutely essential in close-knit rural communities where it was neither necessary nor a value, where it was neither a necessity nor a value. For instance, he says, the ceremony to celebrate a man's second marriage would normally be simplified. Similarly, the wedding might be abbreviated by reason of poverty and the need to expedite matters. In paragraph 79, this is what the learned Judge Salduka says. Customary marriages are recognized by both the Constitution and the Recognition Act. The Constitution does not define customary law. The Recognition Act does. It defines customary law as customs and usages traditionally observed among the indigenous African peoples of South Africa and which form part of the culture of those peoples, and attempts to give context to the provisions of the Constitution. The Recognition Act defines the customary marriage as a marriage concluded in accordance with customary law. And 2, a customary law marriage entered into after the commencement of this Act, which complies with all the requirements of this Act, is for all purposes regarded and recognized as a marriage. And here there is no talk about the handing over. There are only 3 requirements. 3. 18. Lobola must be fixed. And there must be a celebration, or the marriage must be entered into. So these extraneous other requirements, these are abrogated by the passage of time. The law now recognizes three requirements for a customary law marriage. I'm not saying people no longer practice those requirements, but I'm just saying the Recognition of Customary Marriages Act recognizes 3 requirements. Not 4, not 5, not 6. Okay. Right? The learned judge also quotes stupid me. He says, in a judgment I wrote in Maloba versus Dube and others in 2008, this is what I stated in that case. It is tried that in African customary law, that there is no rigid custom governing the time stipulation within which lobola has to be fully paid. What is sacrosanct is the undertaking to pay the agreed lobola. Consequently, the non-payment of lobola balance, as alleged by the applicant, is not decisive of the ultimate question whether there was a valid customary marriage negotiated or concluded. And in that pursuance of such negotiations, lobola was fixed. In my view, lobola was fixed at 6,000 or 4,000 is not decisive. The fact that lobola was fixed and agreed upon, that is what is decisive. It is tried in customary law that the payment or part payment of lobola is accompanied by a ceremony symbolically joining the respective spouses and families together as one. This ceremony is conducted with customary law and is manifestation of the celebration of a customary marriage. But, as I said, differing with my brother Rojo Motswato and Rojo and another Matlapeng, saying that there has got to be a handing over. I'm sorry, this has been overruled by the SCA. The SCA just says there are three. This is just a conflation of judges conflating Section 3 of the Recognition Act of Customary Laws with traditional customary law practices and traditional living customary law. So, my view then is that the applicant, according to the law recognizing traditional customary marriages, and Mrs. Jaba complied with the law, and consequently, in my view, a customary union between the applicant and the deceased Jaba was contracted. And to adumbrate that conclusion, there is authority which says the handing over can take a symbolic or uxorelical form. And also, it is said that there is no hierarchy of requirements where customary law marriages are concerned. I just say that because there was no handing over, there was no marriage. This is what they are saying. That's not correct. Customary law is not rigid. And if one considers that there are several decisions in the Constitutional Court and in this court which are a study of judicial flexibility in customary law. See, for instance, the case of Shulumbana and others versus Nwamatitwa, 2009, 2 SA 66 Constitutional Court at paragraph 49 to 55. See also Mabena versus Letswalo, 1999, 2 SA 1068 2 at 1074 to 75. See Mabuza versus Mbata, that is the Shope judgment, 2003, 4 SA 2018 C at 226. Further, Section 3, 1B provides that a customary marriage must be negotiated and entered into or celebrated in accordance with customary law. This italicized words indicate that the legislature acknowledges that there are many different communities in South Africa whose marital matters are regulated by some or other body of customary law, and that there exist many different strands of customary law. Each community is governed by a set of customs and usages that change and develop all the time, and the Constitution has been the major catalyst in this regard. It's not me saying that. The Constitutional Court, in fact, says in Shulumbani that handing over is not a requirement for the recognition of a valid customary law marriage. And the learned judge says these developments have not left the handing over of the bride as a requirement of a customary marriage untouched. It is also true that the adherence to the ritual has never been monolithic, as indicated above. The different communities practice it differently and execute it differently, as in the case of Mabuza, for instance, which condoned the non-performance of ukumekeza, a Swazi version of handing over, which also involves the bride appearing naked in front of the female adults in the groom's family. Are you a virgin or not? Those things have been abrogated. It's also accepted that the bride had cohabited with the groom for 8 years. In this case, she says 9 years. And had regarded herself as the groom's lawful wife, as the applicant is regarding herself. She has some documents here where she says she was referred to even at the memorial, which was held as a wife. And in some of the texts which are screened, a member of apparently the family of the deceased Jabba made a proclamation and stated that Jabba lives behind her father, etc., and his wife, the applicant. So, Becker, in Simon's Customary Law in Southern Africa, which was published in 1989, at 109 and 114, he says the ritual is symbolic or uxori local in nature. The uxori local handing over may involve the slaughtering of a beast by a father or the guardian of the bride to signify the acceptance of the groom to the family, or as an indication that she is free to join him and his people if she so wishes. This is very much in line with the view that in customary law, scrupulous attention to the rule is seldom vital, particularly where a man is already married, well, not in this case, or where there is pregnancy and the intending parties seeks to expedite matters for themselves. Like in this case, the applicant says he intended attending a ceremony where lobola was going to be discussed, and it ended up being a marriage. And as conceded by the respondent's counsel, this is not an impossibility. Cohabitation is another factor that needs to be considered in these circumstances, particularly where the bride's family never objected to it or did not display any opprobrium. For example, exacting a fine from the groom's family. Becker makes this point precisely and concisely by saying, proof of cohabitation plus the receipt of the woman's guardian of a substantial number of cattle may raise the presumption that the customary marriage exists. And there is no cogent evidence in rebuttal of the presumption. The court will definitely conclude that a valid customary union exists between the parties. Okay, I'm through with quoting the law. But what is important for this court? It's the text, section 3 of the recognition of marriages and the judgment of the SCA and the judgments, the 3 judgments of the Constitutional Court. Handing over the bride is no longer a requirement. Okay? Consequently, my finding is that then the applicant is declared to be the customary wife of the deceased Jabba Matsobane. And the question that the marriage was never registered within 12 months as decreed by the Recognition Act is not preemptive of the authenticity or the existence of a customary law union. Initially they said you must register the marriage within 12 months, and the minister by decree or regulation came and said 3 months. I think the last such regulation was in 2010. But our law holds that the fact that a customary law union has not been registered does not mean that it is not valid. Okay. Let me come to the interdict which is sought by the applicant to stop, as it were, the funeral service which is arranged for Mabatu tomorrow. Strictly speaking, she has a right to stop it. But this court is aware of the fact that our law is not extinctive in its approach. A law doesn't obtain in a vacuum. This law, in context, takes into consideration that the deceased was a well-known musician, and that the deceased originates also from the Western Transvaal, Mahikeng, Northern Transvaal, Northwestern Transvaal, and that the family of the deceased have already made arrangements. And these arrangements to bury the deceased include also government agencies like the City Council and the Office of the Government of the Province. And I believe that the concept of Ubuntu, and this is not a flighty concept, it's part of our law. The Chief Justice Langa, in this judgment of Mbe, which was quoted by the councils here, spoke about the concept of the African concept of Ubuntu. And I implore the applicant that as an African, and as saying that Jaba was proud in practicing her African origins, it would a major funeral like this, which has been arranged, which involves people traveling possibly from all over the country to come and pay respects at a venue which has been identified. And I want to request that this concept of Ubuntu must be given traction in this case, that fairness and equity and the balance of convenience dictate that there are other interests which are predicated in this application. The deceased, and like me, if I die, I think it's only my family that will turn up. But the deceased was a national figure, and he deserves a decent funeral which has been arranged by the father, who I believe did that, amongst others, out of his good heart. And I would implore the applicant to attend that funeral in the spirit of Ubuntu. As a consequence, using the discretion which I think the court can exercise in this peculiar circumstances attended to this case, the interdict to stop the funeral from taking place is denied. But further, this court has an undertaking from the family of the deceased that the applicant, if she so wishes to attend the funeral, she is not prevented from doing so. Okay. Regarding the spoliation, I'm with the applicant's counsel that the applicant had access to the premises. Mr. Robert Tambo drove from Mabatu all the way to Renpark Ridge. I used to act in Mabatu in the early 200s. Takes you 4 to 5 hours to come to the house in Renpark Ridge. And he found already that the applicant was already there, having access to the house. The applicant says she exactly on the day the deceased died, on the 24th, she actually entered the bedroom and found a cupboard with, I think, it's a blanket or a shawl or a duvet, and actually held the applicant's hand and prayed. I mean, the deceased hand and prayed. So this shows she had access. And suddenly, thereafter, the keys and the locks are changed. The fact that she was on fed-up leave, as we say in the location, doesn't detract from the fact that she had a relationship with the deceased, which I just have endorsed that it was actually more than that. It was a marriage in terms of customary law. So consequently, the order regarding spoliation is also acceded to. Right, just assist me here. So what falls off is the sub-orders to say the remains must be... So basically, the declarator is granted, spoliation is granted.
That would be with respect
Yeah. Prayers.
Page 2,
Prayers 2.
And 3.
Right.
And then 4 falls away.
4 off.
5 falls away.
Right.
6 falls away.
Right.
One of it. The other is 7, that's together.
So it's just 2 and 3.
And then the Lord, the paragraphs 8 and 9 pertain to the spoliation. We submit that those should be granted in terms of what the Lord has stated.
So it's prayers 2, 3, and 8 which are granted.
And
Costs.
And 9.
9 pertains to what?
8 and 9 are 2 parts of the...
Same
One
prayer.
is pertaining to the loose property, the other is pertaining to the house itself.
Right, okay. Okay, so prayers 2, 3, 8, and 9 are granted. And the question of costs?
The board, the parties are in agreement that 2 counsel had been used. Both parties have argued that the successful party should get the costs. We will simply deal with one point to say that the applicant had substantial success had to come to court in the circumstances,
Yeah.
and that should be determined.
Okay. Okay, costs of, including the costs of 2 counsel are granted against the respondent. Okay. Okay, that's the end of the case. Thanks. All right, Kotola Jen.
All right, well, there you have it, live visuals from the Johannesburg High Court. The judge there ruling that Lerato Sengadi is the wife of the late Double HP, of course, under customary law. It wasn't quite a very lengthy judgment, this one. The judge has been quoting previous judgments to substantiate what he was about to rule on. But the judge basically saying that as much as customary law recognizes Lerato Sengadi as the wife to the late to the late Double HP, but the interdict to stop the funeral has been denied. This means that the funeral will still go ahead as planned in Mahikeng tomorrow. The judge basically saying that Double HP was not just anyone, hence they denying this interdict. Preparations have already been made, those of course involving the government. As you may know, that Double HP has been given the official provincial funeral by the provincial government in the Northwest province. So they're just saying here that the spirit of Ubuntu has to prevail. Lerato must take into consideration all the arrangements that have been made, as the deceased was a national figure who deserves a dignified funeral. So that's of course news breaking out of the Johannesburg High Court at this hour. The interdict to stop the funeral service over the late Double HP has been denied, but the judge adding that the applicant in this case, who is the wife now, Lerato Sengadi, is allowed to attend the funeral which will take place. But going forward now, Lerato is recognized as the wife to the late Double HP, of course, that under customary law. It's a very, very interesting discussion to many people. So after the news at 5, we'll have Dr. Mathola Motshekga. He is, of course, the expert in tradition and culture, who will, break this down for us, as there are many elements which came out of this particular case, of course, the issues around culture and